of the hearings panel called for the purpose of hearing submissions in relation to an application to subdivide a 9-hectare property into 2 new lots adjacent to 999 Luggett Cromwell Road. I'd ask the Minute Secretary to report on proceedings today.
All statutory requirements under Section 95 of the Resource Management Act have been complied with. Report of the planning consultant has been circulated to Address for Services. The submissions received have been identified in the report.
Thank you. The following procedure will be followed for the hearing. The panel of officers may ask questions. Council's officers or its consultant shall put any questions through the chair, and the chair shall be deemed to be the person asking the questions. The applicant or the applicant's representative shall make submissions and present evidence. The submitters or their representatives shall then make submissions and present evidence. The planning consultant shall then make their submission. The applicant shall have the right to reply, but shall not be permitted to again traverse the evidence nor raise new evidence. So before proceeding with the hearing, I'd ask for all parties appearing to identify themselves. So I've already identified Campbell as the on behalf of the applicant, and Greg Shepherd as one of the submitters. And we don't seem to have Stuart Hawker or John Ellison. Stuart or John, if you're there. Oh yeah, John's accepted, but he's not there. Right. So I'm sure if I don't see them join, Nicole, you'll pick me up and tell me that they're there, won't you?
Yes, I will. Yes.
Thank you. Right. On that basis, then I'll move that the report of the planning consultant be taken as read. Seconded.
Second. Yes.
Martin, all in favour? Stephen?
Aye.
Carried. Thank you. We'll pass over you to Campbell. We'll pass over to you, Campbell, to take us through your the applicant.
Problem. Thank you. Yeah, for those of you who don't know me, I'm Campbell Hills. I'm with C. Hughes and Associates, Surveying and Resource Management. I've been working in this capacity in resource management planning and engineering for approximately 7.5 years here in Central Otago, and I took over this proposal when Tony Cox retired from our company last year. So I didn't prepare the application or the scheme plan, but I've certainly made myself familiar with it all. I have been to site, and I do understand the proposal and sort of the detail around it. So yes, I have prepared the further evidence, which hopefully you'll have in front of you.
Yeah, we do.
Dated 21st of January, which really just focuses on key points raised in the planners report, the Section 42A report, sort of with the mind that sort of encapsulates a lot of the detail in the application and the submissions. So, yeah, I suppose just to start off with, in terms of I do need to just mention that obviously the applicants aren't disappointed they couldn't be here today, but just with the time frame and the notice that they had other commitments. So if there is anything that comes up that they need to specifically address, then we can certainly do that, provide that communication. But yeah, hopefully I can address any of those matters. So yeah, from their point of view, this has all come about really because they have obviously planted out quite extensively the large flat area of the site in Cherries a couple of years ago, a few years ago, and that left this area at the western end, which is a lot, quite different to, I suppose, the area that has been planted. They've planted what they could reasonably plant and manage and get a return off, and they've left the terrace portion at the western end for some alternative land use, which they have, I think struggled with in terms of, obviously what do you do with that balanced area that is a lot more undulating and obviously historically has been part of a wider pastoral grazing farm, but is now 2.4 hectare portion that's fenced off separately and is growing weeds essentially. So there is no current residential building platform registered on the property, but it is a reasonable expectation that if someone was looking to build, they would build up on that terrace where there are neighbouring, the neighbouring properties do have building platforms. So yeah, I mean, regardless of whether or not the subdivision proceeds, there is a reasonable expectation that there would ultimately be a residential dwelling sited, if not where we've shown, certainly somewhere in that western portion of the site. And that would be assessed as a discretionary restricted activity on its own, with the controlled activity aspect as well, which obviously brings in the detail around colour and cereals and that sort of thing, along with a few other things. So the applicants arrived at this position because they obviously want to build a dwelling, but they also wanted to have the orchard as a separate unit for their own financial reasons. They don't have a need for an orchard manager to reside on the property with the orchard. And I think that's one aspect that I have covered off in my further evidence, is that there are a whole lot of different scenarios for what might be considered appropriate use or productive use. At the end of the day, every situation is different, and sometimes, as is the case here, this orchard block is not reliant on the need for a residence or a manager to be situated on site. So they obviously want to separate it out because, well, for a few reasons. It's a bit of a maintenance burden for the remainder of the orchard, in terms of just keeping the grass down, because they don't, as far as I know, they don't have their own stock, but I couldn't be sure of that. And they don't want to overcapitalise the rural orchard block. So they've arrived at this point where what we're proposing is a 2.4 thereabouts hectare property, which essentially would have the same land use, I suppose, whether or not the subdivision goes ahead. It's just that it would, from a property ownership point of view, it would be more difficult ownership and management point of view, because it's still attached to the orchard, developed orchard. Yes, so I mean, obviously I worked through all of the matters that have been raised. There is quite a bit of detail in some of the submissions, and I'm certainly happy to work through that now. And obviously there are a few considerations. The obvious landscape and visibility, which I mean, from my perspective, there was, although there's not a permitted baseline there, there's a reasonable expectation that someone would be able to build up there, even if it wasn't a residential building platform, that there might be a shed or something of that nature which could be more dominant. And yes, and then the one of the other obvious matters that was raised was the reverse sensitivity issue, which is very common anytime you're looking at rural subdivision or residential activity in the rural environment, and needs to be managed appropriately. And generally, if there are conditions registered, my understanding is that they do serve purpose, and they do protect those adjoining land uses. There's obviously a requirement there for people to, and it prohibits those sorts of arguments, I guess. But yeah, it is a point of contention, obviously, whenever you have that residential activity, but at the same time, you can't really avoid the scenario where you get those residential activities situated amongst other productive rural activities, and it just needs to be managed appropriately. And that has been detailed in one of the volunteered conditions, well, not volunteered conditions, but the draft conditions, as an ongoing condition that would be registered on the title. Access, I had a bit of a look at that myself. Obviously, one of the owners who uses this access has done a good job of maintaining that himself. I'm not exactly sure what arrangement has been made with all of the different right-of-way users, but yeah, it has been formed and maintained to quite a suitable width. But obviously, any further upgrade that is deemed appropriate, the applicants are quite happy to go along with. And one of the submissions, I think, from Greg and Joe Shepherd, raised the point about dust suppression, which the applicant does also fully support. So yes, and one of the other key matters that did come up was was raised in the Section 42A report, was the topic of cumulative effects. Yeah, obviously the cumulative effects are quite difficult to assess on a case-by-case basis, but the way I sort of looked at it was, well, you sort of look at what the reasonable expectation might be in terms of what built form could take place. Essentially, the status quo is being maintained with this proposal, regardless of whether or not the subdivision happens. It's just going to be obviously more difficult for the applicants to manage, but yeah, in terms of the cumulative effects, I saw that as being very much limited. And following on from that, obviously, is the precedent argument, which precedent matter and plan integrity, and whether or not this does set an undesirable precedent. And obviously, you need to establish a true exception to avoid that precedent being set. And it's a case of every case is assessed on its merits. And in this situation, because the applicants are volunteering a condition to go on the title that prohibits residential activity on lot 2, I think the potential for the cumulative effects, whereby someone might buy lot 2 and say, oh, well, I want to build my house in here. Lot 2, if ever sold, would be sold as a productive orchard property rather than a potential rural lifestyle type setup. So that does obviously carry a lot of weight in terms of the ability for someone to argue precedent. And also, just the characteristics of the site. You need to look at how things are laid out, how they fit in relation to each other, the topography, the visibility, the potential for someone else to be in that similar scenario. Like, if someone's going to argue precedent, they need to have a pretty strong case, with similar sorts of scenarios at play, where you're offering a condition that prohibits residential activity on one part of the site, or one lot, sorry, where access and servicing is achievable, all of that sort of thing, where in my mind, this lot 1 area does really lend itself as a standalone property. It's separated from the highway. In terms of visual effects, it's largely screened by the orchard activity in the front, although you could rely on that. And the buffer is there regardless, and the minimum, the lot size is still above the minimum. And I think in section 42A report, it was noted that this situation could have come about as a through the average, and still complied with the average and minimum lot sizes if the previous subdivisions had been laid out slightly differently. Regardless of that, you look at the land form, the areas that are and can be productively used. You're left over with these areas on these sort of 2 or 3 lots that can't really be productively used any longer. In the past, obviously, they were part of a larger pastoral grazing farm. Then it was quite easy just to open them up and just have the stock roam across. But there you've got these fragmented areas where you've got previous subdivisions that have sort of carved across the terrace and the flatter lower lying areas, the terrace riser and the terraces themselves, and resulted in this sort of disjointed or fragmented landholding scenario. So it's sort of something that I often look at whenever someone approaches me is, if they're looking to do a subdivision, are they acknowledging the landform? Not, because otherwise they're potentially creating awkward properties for future ownership, future maintenance, and productive land use. And sometimes these areas do end up with areas that lend themselves to more of a rural lifestyle type scenario. I believe that the bulk, flat, productive areas in larger holdings for that purpose, for orchard activity, vineyards, whatever it might be. And this is certainly one of those cases. And I think if anybody's going to try and argue precedent, then it needs to be a like-for-like type scenario. And certainly they would need to be offering similar types of conditions to what the applicants, or what we have on behalf of the applicants. That is really probably all I have for a start. And I guess, just if anybody's got questions, I'm sure there will be questions, and hopefully we can work through those.
Thank you, Campbell. I'll just start off. The way that I am reading the Section 42A report is that the planning consultant has said that pretty much on all but precedent, the subdivision request could be able to be approved. And then that puts the panel in the situation of going, well, how do we work out what the precedent's going to be? And I think comes back to then is saying, well, when you create an expectation, so if this one was to be approved, what if I was next door at 999 Luggett Cromwell Road, I'll go, ooh, I can carve off everything below the dam, and the argument's just the same. And I'm sure that while you were talking, I was having a quick look at the other lot holdings that are in the area, and I'm sure that you could make that precedent argument for every one. And the dilemma that leaves the panel with is saying, if you say yes to one, what is it then that creates that tipping point or the cumulative effect, by which case then you say no?
And I think, yeah, there are obviously a few things to consider there, but the obvious point there would be that if you bring it back to an effects point of view and what's actually perceivable, even if they did, provided there isn't already a residential activity on that lower lying or productive area, the perceivable effects are possibly the same, provided that they apply similar conditions around, no residential activity on that productive land area. Whether or not there are dwellings constructed already, and I did have a look at that myself. Obviously, every area is unique as well, but if we look specifically at this area, we've got 999, like you say, to the south, which I don't know actually whether there is a residential building platform already registered over that terrace riser portion, but certainly it appears as though if there's a shed there now, and there could quite easily be a dwelling over that site. So yes, they possibly could apply the same argument, and you end up with I suppose a clustering of these more rural lifestyle properties in here with a buffer to the highway, appropriate conditions to restrict residential activity over those developed areas, orchard areas, or vineyard areas, and suitable control or conditions in relation to reverse sensitivity being registered. I don't see that you could really take this particular scenario and then apply it directly to anywhere else. And certainly the district plan does allow for, whether it considers whether clustering is suitable or not. I know that there is in one of the assessment matters that does get raised. And potentially, because you've already got a scenario where you've got three, regardless of whether the subdivision happens or not, you've got three or four properties across this terrace riser that could have a desire to build, the owners could have a desire to build on those areas, and certainly already two of them have established built form on them. Then I don't really see it as cumulative effects if the scope for that built form is limited to each of these lots that exist now. I'm not sure how things came about to the north with 1003, where you've got this area that's sort of, if you look just north of that, you've obviously got a planted orchard area and a narrow strip through between 1003 and 1009 that gives that other site a portion of the terrace riser. Sort of seems a bit odd to me, but anyway, yeah. What I'm saying is that in my mind, any potential for cumulative effects is sort of limited to the what we have on the ground there now, and to this particular terrace riser. And if someone was going to apply a precedent, then certainly they possibly could apply the same conditions is what we're proposing for this specific location, and establish their own residential activity, which there are already residential building platforms here anyway. So it comes back to that whole status quo, I suppose you say, and what is the net effect of the subdivision itself. And I think that's certainly, there's not a lot to that. Really, the effects are established by the built form, the residential activity, which could occur anyway. And then you're looking at, obviously your visibility and access, service, and whether that's appropriate or not. So I would be limiting the potential precedent argument to this particular site and to these 3 or 4 properties.
Yep. Thank you. I'll have to say you didn't help me at all.
That's quite all right.
but it is quite right. Yeah, I understand what you've said. Thank you. I don't have any other questions. Councillor McPherson.
I share your sentiments with being just adding to the confusion.
No, I won't call it confusion. I'll call it just making the task harder than it already started out to be.
Yes, the challenge.
Councillor Jeffrey.
No, nothing from me. It's just that one of the arguments used, I don't particularly like the argument that the unproductive land is a burden on the productive land. Don't see the logic behind that, to be honest. Because you could use that across land anywhere in Central Otago.
Yeah. I suppose it sort of just comes from the point of view that if you've got an area of land that is sort of uniform and easily managed in one sort of land use, then the level of productivity could be higher because you're not having to invest in maintaining. But I understand that obviously it is certainly couldn't be applied in every scenario, and everybody's situation is different. So again, it makes it very difficult to.
That brings me back to one question I probably should have asked, and you've just prompted me to think about it some more. Is that so? Part of your supporting arguments for proceeding with the application would be that the no build covenant on the productive land means that there's no more residential use or activity. Of course, that'll never stop someone from trying potentially in the future, but that is does provide some level of protection, if you like. Would that go so far as to also putting another clause that said no further subdivision?
Yeah, I'm sure it would. I'm fairly confident that the applicants would support that, but we could certainly confirm, because yes, that obviously does help as well. Personally, I would never ever consider it, but I guess some might, and some might raise some valid arguments. So yeah.
I suspect there's no guarantee that when they originally did the subdivision, they contemplated that someone would put this application in either. So while you look at it and go, yes, that makes sense, but actually in 5-10 years down the track, what we thought made sense, there's a different mindset and thought processes and different world going on. So who knows what can happen. I'm not saying that's going to make the difference either, but it would be something that I think that may assist or not. No other questions from the panel. So thank you, Campbell. We'll pick you up again at the end. We should have, Stuart Hawker had indicated that he was going to appear and to support his submission and support, but just checking, I don't see Stuart on my list of attendees, so I'm going to assume that he's not there. Nicole, can you tell me that I'm right, please?
He is not there, but I also can see that John Ellison has left the meeting again.
Oh, okay. Because I was going to go to him next. All right. Yes, he was there for a while.
Yes.
maybe could you just, I think you may be able to send him a message to say, is he coming back or not?
Correct. Yeah, I can give him a message or try and call him back in.
Yeah, that would be good. Thank you. In the meantime, the batting order is going to be slightly out of kilter if John Allison or Stuart Hawker do join us, but we'll cross that bridge when we come to it. But Greg Shepherd, you are there, and you made a submission opposing the application, so which we have in front of us. So your chance to speak to your submission, please. And if you are, you'll have to unmute yourself so we can hear you. It would be helpful.
Yep.
You're still muted, Greg. That's all good now. Yep.
There we go. Can you hear me now?
Yep, we can. Thank you.
Look, thank you, Mr. Chairman. Thank you to the hearing panel for allowing me to speak and be a part of this. And I thank you, Campbell, for the detail that you've put forward and to date to try and give some clarity around what is proposed and what that might look like going forward. Essentially, I guess what I'm going to talk to in particular, probably the key points that sort of come out. You've no doubt all had a chance to read my submission, so I deem that as tabled and read.
Yep.
Essentially, look, we support development. It's the nature of the beast, in the sense that population grows, therefore more people need to be catered for. And that's pretty plain and simple. I think the planning rules, be it good, bad or otherwise, provide a framework for everyone to work in, and they're there for obviously the council and this hearing to sort of measure a submission or an application such as this. Essentially, the key points that I'd like to raise and pull out are the road upgrade, the potential for worker accommodation, the reverse sensitivity, services, and I guess a couple of notes from the discussion so far. So the road upgrade, so as I saw it, the engineers have made their assessment. They have recommended that the road requires upgrade. I'd like to point out that, as I understand, there's 7 parties using that road at the moment. The potential for so therefore a road upgrade is inevitable. And I support the upgrade. What I'm concerned about from our position is the potential impact on our title area, and also the implications as far as setbacks are concerned for building farm buildings and the like that would potentially impact on that position of the road. I guess further to that, we haven't had any sort of correspondence with the neighbours and therefore the applicant with respect some work that we've been trying to do and have proceeded with. So it makes it very hard to understand whether or not we're going to get that engagement other than a formal method such as what we're going through now, which I'm fine with, but it just doesn't make for good decisions and good negotiation on the ground. So, so the other point that you raised, that was raised, Mr. Chairman, was regards to the dust suppression. Within the response from Campbell, it would be considered rather than it is actually going to occur. So I'm not sure where we stand on that. So it's very, very hard for us to make an informed decision when it's the information's not clear. Also, if this upgrade is to occur, it would, to my understanding, result in the potential for vesting in public land, as the road would be up to a certain spec. I also understand that requires an agreement with all neighbours. So I guess until I see what the design of that is, then I have no no view on whether or not I should actually support the vesting as part of that process as well. And obviously the vesting has a material impact on our title area, so as mentioned. I guess moving on, worker accommodation. So within the application, there's the forfeiting of residential accommodation on lot 2 on the lower flat, which we understand the rationale why that's there. What is not clear is whether that means that they're forfeiting the right to put any worker accommodation, which I believe through rule 4.7.37, it would be restricted and not allowed, but it's not clear in the condition that has been specified in the 42 report. The other item would be seasonal worker accommodation, and whether or not that would be allowed as well. So that condition, I guess, needs to be framed to make that abundantly clear of what is and isn't allowed in respect to the worker and seasonal worker accommodation. Further to that, I guess if lot 1 has a residential building put on it for the intent of the applicants to reside in, does that restrict them from putting worker or seasonal worker accommodation in lot 1? It could, I guess, be argued that they're operating the business, the 2 properties as one still, and therefore it might be feasible to have that argument. I guess I don't know, Mr. Chairman. We accept wholeheartedly that it's fine to put a residence up there, and as you'll see on our title, we do have the building platform, so I'm not opposed to having a residence up there. I guess it's what that means from a subdivision point of view, and the reverse sensitivity detail has been talked about, and I guess everyone's well aware of the impact that can have on productive land within the region that's providing us revenue and a life. I guess having a residence up there doesn't preclude the occupants of the outcome that they're ultimately look for, and I guess in many respects it could be managed through a lease of land rather than predominantly just having a title change. A title change to me opens the door without doubt for a sale, and that needs to be therefore seriously considered, I guess, from the panel's perspective. I guess the services, we have a potable bore at the bottom of our block, not dissimilar to the positioning of the bore located on lot 2. We have ensured that it's within their boundary lines, and I guess what we want to make sure is that any water requirements that lot 2 in the future may need are considered from that bore. Ultimately, orchard workers still need drinking water for a safe and healthy environment, or working environment, and it would seem ridiculous that bore water allocation is only allocated to lot 1 up on the top terrace, and therefore not considering lot 2 or certainly the productive orchard area. And the potential for having more bores on that area would draw more pressure on the aquifer that's quite limited in its flow, as I understand from our own analysis. It's certainly not irrigation water viable, so any draw on that is consistently reducing the flow. So I guess that should be considered as part of any subdivision decision that if it does go and get accepted. I'd like to just reiterate the management of weeds is certainly not the responsibility of a council to subdivide. I don't think that's fair, and as has been highlighted, it's not. It's a management issue for landowners, and that's something that we should take on board, not council. I guess just to further to that, calling this land unproductive is probably a bit of a misnomer. In my mind, it's undeveloped, and there's plenty of undeveloped land around that we would all love to have more production out of, but that's priority of investment and for a number of other reasons as well. So I think that shouldn't have any weight essentially to the argument for and reason for subdividing. I guess further to the sort of the cumulative effect and the precedent argument, reducing these land holdings to a smaller land holding and on the understanding that it's either leased out or managed by a bigger consortium or whatever, still subdivides land and reduces the land area that's available for owner occupiers and economic units. So in the event that the cherry price changes, which is the current use of the lower land, that might make that unit uneconomic. We don't know, and heaven forbid it doesn't happen, because I'll certainly be impacted by that as well. But the result is that subdivision of a small lot that is deemed as a rural area for productive fruit production, if you like, and that's been evidenced in a report that we've gained from our consultant, that essentially it's going to limit the future. And I guess, Mr. Chairman, further to your comment around no further subdivision, I guess that makes it very black and white, and all around precedents, then is that a wider discussion that should be had with the public for that terrace riser area, and if so, a consideration for future plan change to allocate that terrace riser as a rural residential. It feels in my gut that it would be the sort of thing that should occur if we think we're going to go down a precedent's path, and not put yourselves or the community in a position where we're getting these small lots created when it's not actually the intent of, regardless of what the planning might or might not allow. So yeah, and I guess just this task should be straightforward. It should be a relatively simple yes or no. I think there's evidence in previous applications, and I would like to draw attention to RC 200-361. So that's 200361, which was located in Omakau Shadow Creek. With reading that application for subdivision, it had a very similar feel to it, and I guess the panel at the time felt the same, and it seems that one was declined for the precedent's effect and the like. So I guess that be considered. I don't want to sit here and be the not in my backyard person, because I'm certainly not that sort of person. I support subdivision, I support development. It's I think it's got to be done the right way, and for me this one just doesn't sit quite right, and I am an impacted party. I get that.
Thank you, Mr. Shepherd. You have led us towards RC 200-361, which is quite helpful, and this panel actually was the decision makers for that particular one. So I was very familiar with that. Sorry if you can hear that. It's a low-flying aeroplane somebody on the airstrip that's at the other end of my house, probably. That's gone. You mentioned, it's quite good because it gives me some context. You mentioned about land and its productivity and your view that land is not necessarily unproductive, just undeveloped. And I guess if you went back a number of years and said to the people that this land is unproductive and then showed them the same land now with cherries and grapes on it, they probably would say, never thought that was going to happen. The two parcels of land, are you familiar with that bit of land down on the Omaka Cheddar Creek Road?
Only from the aerial view, from what I could make out. I guess I've driven past what I think a couple of times what it is, but I can't say I'm categorically completely aware of it.
Yep. So using your logic, you'd contend that that piece of land is not necessarily unproductive, just undeveloped.
Absolutely. Yeah.
Okay. And I guess does it go so far as to say that undeveloped means that its productive use may be yet to be found or achieved? Absolutely,
and I guess the applicant's trying to do that through subdivision, and it's creating a development. So, it's in its natural state at the moment, and no one spent much money on it, and therefore it's undeveloped. It's not. It's still got future potential. That, I guess, that was positioned in when we got a report done for our block of land of what we were going to do with it. It was mentioned on the ground at the time by our consultant, who is, I'm sure he won't mind me mentioning his name, is Ernst Weaver. But basically he indicated that the terrace could grow apricots as an example. I don't have that in a report, but I do have in a report that it was stipulated that the whole land area had the suitable soils for growing, certainly growing cherries if we wanted it, or stone fruit. So. And
I think I'm picking up your comment about what the district plan currently provides for, and to make these sort of changes may be something that the community should have a wider say on. And I guess at the moment the communities have the say to say, well, that the expected minimum is down to 4, but an average of 8, and that should generally expected when it was done to provide for a productive use. And I guess, do you think in this case here, if I look at your block of land to an extent as well, and this one and the neighbouring one to the south, is that perhaps the intention would more likely have been is the general more productive use on the flatter area and the associated lifestyle to go with it, or living and other work stuff on the terrace riser. Do you think that would be more what would be in keeping with it?
I guess everyone has a preference on how they use their land, but in some respects, yes. It does make a beautiful building platform. I can't deny that. We've got a beautiful spot up there that we'd love to build on one day once finances allow. But how they use it from a service area for the orchard, we are ourselves going to put something down on the bottom because it's nice and handy to the orchard. So I hear the applicant's argument in that position, but I think it should be noted that the applicant does share resources with the neighbouring property. It's not like they're a standalone unit. So that arrangement is a current state. It's not necessarily future state, but yeah. I think just you mentioned about lot size as well. I think the other thing is if, I'm not sure if I said it before, but if there is any vesting of land in the council because of the right-of-way upgrade, and I guess if there is agreement around the table for that vesting, that does restrict or reduce the land area of those lower lots as well, and ours is impacted by that, as I mentioned. So there's a further impact of the right-of-way vesting if that was to occur.
No, thank you.
Thank you.
Nothing from me.
Thanks, Stephen. Martin?
Nothing from me, thank you.
Thank you. So I'm just going to check and see if we had any luck getting John Ellison back.
No, I tried him about 4 times, so
Oh.
I can't seem to get him.
No. Well, so the key thing is, and just to record it for those that are listening here now, that we've seen John's submission, and it was, I think John's one was buried it in bits of paper here. He neither supported or opposed, but had some concerns, and the other submission from Stuart Hawker was in support. So so we've got those submissions, and as part of our going forward, we can take that into account. John, you as the planning consultant that has authored the 42A report, an opportunity for you to speak to your report and any questions or observations or clarifications or amendments you'd might like to make, having heard the submission from the applicant and from the submitters. So I'll hand over to you. You're also muted as well.
Sure. Okay. Am I hear me now?
Yep, good as gone.
Yes, I don't think I need to make any changes to the report. You know, I know Campbell's raised some issues with it, but I generally think it's covers all the issues and outlines my position. In terms of the submissions, the engineer hasn't recommended vesting as far as I'm aware. So I don't necessarily think the road needs to be vested for the number of users on it. So yeah, I haven't recommended vesting in the conditions for the subdivision. In terms of workers' accommodation that was raised as a potential issue, I mean, I had a quick look through the definitions. I mean, I think in terms of lot 1, the approval of the platform and the land use consent for the residential activity on that platform is still subject to a further consent process. So if there were to be a workers' accommodation on lot 1, for example, there would be, you know, a further consent process that can manage that. And in terms of lot 2, I think the restriction for residential activity would extend to workers' accommodation, but you know, if you wanted to make that explicit, you could potentially add that into the condition. Yeah, so that's what I'd say on that particular point. In terms of services, I'm no expert on bore water, so I've just relied on the engineering advice that I've been supplied and the conditions that were recommended by the engineer. So I'm not really in a position to elaborate too much on this particular area and the restrictions of the bore supply. I can't really assist there. In terms of the precedent argument, you know, I accept what was said in terms of this might be a limited precedent because it does have some features of it that are you know, wouldn't necessarily be transferable in a broader sense to the rural area. You know, it's so I see the point that's being made there that you know, you could argue that that the precedent is somewhat restricted to the particular terrace riser, and I think the point that I made in my report was just that that the committee be clear about that in their decision making should they decide that the precedent in this case is not undesirable and the consent can be issued. So forever, because people will look at other consents and you know, Mr. Shepherd's had a look at another consent and had a look at the committee's decision and applied its applicability to this particular application. So I think it's important just to be clear in the decision making about, you know, whether you consider there is a precedent or not and the reasons for that. In terms of, okay, sounds like you made the decision on that particular one anyway, but for me the point of difference appeared to be the fact that that particular subdivision, one had a house on it already and the other one was proposing a platform. So there's a clear difference with this application in that, you know, there's a consent notice being volunteered that would restrict the development to one dwelling on the overall land. So that's a point of difference between the two applications. So that's probably all I want to say. I'm happy to answer any questions.
Thank you. You've addressed a couple of things that I might have flicked your way, so clarifying them, thank you. Martin?
Nothing.
Stephen?
No, nothing.
Right, thank you. So back to you, Campbell, now for your right of reply. Are you happy to give that, or would you propose to do that separately, or are you happy to do it now?
Well, I will give a reply. Obviously there are, well, thank you firstly everyone for your comments, and certainly going to take on board neighbours' concerns. Obviously there's only so much I can do on my own right now, but yeah, quite happy to put the applicants in touch with you, Greg, and yeah, obviously I do need to have a discussion with the applicants around particularly I suppose the condition that was volunteered, and whether that could be just firmed up with the seasonal worker accommodation scenario. In my mind, that seems logical, but yeah, and I suppose just following on from that, one thing I did notice when I was on site is that there is an area where I suppose the facilities required for the orchard are currently, or the equipment and machinery, that sort of thing, is stored. There is a bit of an area there where it would be achievable to put a shed on or something like that if you needed to cover that stuff. There's one of the comments in the section 42A report sort of related to whether this subdivision would then prohibit the ability to have those facilities on lot 2. And I don't think that is necessarily the case. As Greg said himself, it's quite desirable to have those facilities down on the lower lying area rather than having to drive up and around to access the shed on the top. So yes, I think the short of it is that I think we can firm up that condition that was volunteered in order to satisfy the concerns around whether that allows for potential development beyond simple residential activity for lot 2. In terms of the right-of-way upgrade detail, obviously we wouldn't normally work through a design until after the consent stage, a detailed design, but we could certainly look to do that in advance if that was considered required and appropriate. I can certainly personally work through with Greg and the applicants and the other adjoining landowners through that matter if that is really a point of concern that would sort of cause you to have reservations about granting consent. I don't think it's certainly not insurmountable, and the legal width, from what I can tell, is suitable for the formed width that condition has put forward, because it certainly is in a lot of places already it has a suitable width. It's just a case of firming up that formation to a council standard, but I don't think that actually needs, certainly doesn't necessarily require vesting, and if it's not desired by any of the landowners that use this access, then I'd certainly not go down that approach, down that pathway. Greg raised a good point about, options and whether potentially you could achieve the same outcome with in terms of land use and management with a lease type arrangement. I think, yeah, obviously that is an option. Whether or not that works for the applicants or is desirable in the long term, I don't know. I mean, every situation is different. Some companies may like to, have their own land holding rather than be locked into a lease for some sort of term that then, if they have a few years where things don't go so well, there's a little bit more writing on it, perhaps. I'm not an expert in that, but obviously there are a lot of different scenarios, and yes, the idea with the district plan and RMA processes is that you try to cater for these scenarios in a way that obviously manages or mitigates effects, and the applicants, in their mind, this is a suitable form of land use and development, and it's one that doesn't have any real net effects or adverse net effects. So the water issue, I was in correspondence with the applicants on that, based on the comments made in Shepherd's submission, Greg and Joe's submission. And they did clarify that the bore was intended for Lot 1, but I'm not sure, and Greg may be able to clarify this, whether, because obviously there are already existing water schemes in place that offer or provide water for these properties. Whether that includes a potable water supply, I'm not sure. So perhaps Greg might be able to clarify that, or I can discuss further with the applicants and Greg together, because certainly the intention is not to take anything away from Lot 2. That bore was put in for the purpose of servicing Lot 1, but if Lot 2 doesn't have already a potable water supply and requires it, then we could certainly make provision for that off that new bore. And then, yes, obviously the whole unproductive or undeveloped scenario or situation, it is very subjective, isn't it? And I guess you talk to a few different people and you get a few different answers about what is considered productive land use or not. And following on from that, the wider public interest in how land is used and fragmented and that sort of thing. It does get quite difficult, obviously, because everybody has their own views and their own financial circumstances, and how that is managed is obviously very much case by case basis. But I think, yeah, following on from that, obviously, precedent argument or the precedent matter, whether looking at this, you say, well, it's not appropriate because it could be developed in some way with the rest of the orchard in a productive manner. I don't know whether that's appropriate or not. I mean, you could say that this site could be productive as a standalone unit anyway, even if it was planted in orchard trees. So I'm not sure how that would be managed. Whether there's, with terracing and that sort of thing, obviously there are constraints there. So, but yeah, I sort of had similar thinking in terms of the precedent argument and the Shadow Creek or Omakau Shadow Creek Road example, just making sure that it's like with like, and that that you don't try, you're not applying. Not that I'm necessarily saying that case doesn't apply, but certainly on the face of it, I don't see the immediate similarities where you've got a productive planted block and then a leftover area. So yeah, and I think from my understanding is that this was fully publicly notified, unless I missed something there. But obviously, any public process or public notification, you're only going to capture the people who are aware, who are looking at that stuff, and that applies whether it's the district or non-complying activity or district plan review. So it has obviously gone through the public realm, and submitters have come through that process. But yeah, I think that was about all of the extra I had. Yes, I don't think there was anything further, but obviously there are a few points here that perhaps I do actually need to discuss with the applicants and with Greg, with the shepherds and with the other adjoining landowners, just to make sure that, because certainly the intention is not to try and bypass anyone. I think it's just a byproduct of the fact that our clients are absentee and spend a lot of their time in Singapore and probably are a little bit disconnected with their neighbours more so than what others may be. But hopefully we can provide that forum.
Thanks, Campbell. I think what that sounds like to me is that the best thing for the panel to do would be to adjourn the hearing pending your right of reply in writing. Because it sounds like there's some things that you still need to get some advice on, given the situation of your clients. An opportunity maybe to work some things through, some aspects through with the submitters and the neighbours in particular. And I can see it would be of little value for us to roll right on and adjourn the hearing and make a decision, and then that might or might not work out to everybody's mutual satisfaction. So I think on that basis, unless I'm going to get any advice from my planning consultant or the planning staff that are supporting us here, that's what I propose to do. So, John, any issues for you in doing that? I assume that was a no because you were muted. It was a no, right? Thank you.
No. I think that approach is good. So yeah, that's a good way of tidying up the loose ends that you might want to have tidied up before you make your decision.
Yeah, well, thank you. And Campbell, in saying that, the only proviso will be is depending on what comes out of it in terms of what the submitters say, we may have to have their position confirmed if there's something comes out of it. So what I would say to preempt that, if whatever you come up with, if the submitters have all signed off on it or told us their view at the same time, it's incorporated in your right of reply, whether that's allowed or not, I don't really care. That's what we'll head towards.
Yeah, that's potentially not allowed, but
find a way to make it happen, Campbell. And thanks, John. If it's not allowed, then all I'd have to do then is the panel would issue a minute to go back to the submitters.
Yeah, well, I'm the planner here. You could probably take some advice from the CODC, personnel on that approach.
Anne's coming. Yeah, Anne's coming to my rescue.
Yeah, so my suggestion would be that Campbell has the opportunity to speak with his clients and issue a written right of reply, and perhaps that gets circulated to the submitters. If there's any additional, I don't know if there's any additional information that will be coming forward. Are you anticipating anything additional, Campbell?
No.
Any changes or anything?
No, certainly not. No, it's really just to cover off those points raised by Greg Shepherd, and and obviously to perhaps to engage with Mr. Ellison, because he was here for a short time, but
yeah.
Right, so stand down on my last part and just do the first part.
Yeah. And if it's necessary, if there's anything that's changing, then we can consider whether or not we need to get a reply from the submitters. But generally speaking, circulating it should be okay, I think.
I was just trying to make sure we didn't slow the process down.
No. Yeah.
This one's been going since 2020 already.
Yeah.
That's right. No, cool. All right. So Campbell, if you're happy on that basis, that's how we'll proceed. You'll write a reply in writing, and depending on what that brings out as to whether we then have to circulate, well, will we circulate it to the submitters, and depending on what's in it as to whether we need to carry on from there. But we'll get that underway for a start and go from there.
Sounds great. Thank you.
Everybody happy? The meeting is adjourned.
Mr. Gillespie, can you hold on the line there, because I want to talk to you about another matter.
No, what I'm going to do is we're going to go back onto that other decision-making meeting we had, and we'll do it there. So now
Okay,
the
fine.
other teams when you got. So
Yep.
um,
Done.
Stephen
Got
and
it.
Martin
Leave that
and the
one.
staff go to that, please.
Perfect. Cool.
Thanks, guys.
Bye.
Thank you, everyone.